Hello friends, welcome to Just My 2 Cents. I'm your host Clarinda McGrady, and today I have the amazing opportunity to be here with business attorney, real estate, and estate planning attorney, Ms. LaMonica Love.
Thank you so much, Clarinda. I am so excited to be here, and thank you for providing this platform. It's an amazing opportunity to talk about things that we all need to know about to ensure that we are taking care of our assets and passing them on to our family.
Absolutely.
So I'm so excited to be here. My practice supports primarily entrepreneurs and business owners. And what I've realized in supporting business owners is that a lot of their assets, most of their assets, their business, even though they are in a separate LLC, they directly benefit the families.
This is going to be a great conversation. And I want to backtrack a little bit. One of the reasons why I said, oh my goodness, Ms. LaMonica Love is going to be the perfect guest is because I made a post recently and I was sharing a story that happened where my daughter had a doctor's appointment. I needed to reschedule her appointment. So I called and, you know, the normal, hey, I need to reschedule the appointment. And they looked up her chart and they were like, oh, well, she needs to call and do that. And I was like, why? And like, because she's 18 now. And so it just sort of shut me down. And I was thinking, wait a minute. So I was thinking to myself, if they wouldn't even share, you know, as far as rescheduling a basic doctor's appointment, what would happen if something happened to her?
You know, you're absolutely right, Clarinda. And, you know, so many times women are the caretakers. We are handling the doctor's appointments, whether it be for our children, maybe a sibling that we're taking care of, or for our aging parents. And so oftentimes when we think about these documents, we think about parents. Yeah. But, you know, our babies, when they turn 18, the law flips the switch and makes them, you know, legal, but really we're still training them and helping them to learn and navigate. And so being able to provide that extra support and have that protection is extremely important.
Yeah. Can you explain what is the difference between a will and a trust?
Yes. So a will is actually a document where you dictate and say what you would like to happen to you once you pass away. Okay. So once you pass away, it is going to say how you bequeath things, who do you want to name as a guardian of your children. You can actually name a different person or different persons to take care of your children in the physical sense, and then someone else to manage the finances. With a trust can actually exist while you are living, and it can outlive you. It can actually live through multiple generations, right? So it's not something that activates once you pass away.
Should the everyday person have either a will or trust? And then this is like a two-part question, because so many people think that a will or a trust is for someone else. They think it's for a different demographic. You have to be wealthy, you have to be rich, you have to, you know, meet all these qualifications. But what do you say?
So, you know, I don't think that it's for people that just have all of these assets. And I'll start with a will, and then we'll go to a trust. I think that a will is it's a very inexpensive thing to prepare, specifically if you do not have a ton of assets. I think that it's a good thing to have because you may not have to probate it. You know, there are ways now that specifically in the state of Texas that you can transfer your property, you can transfer your insurance policies, you can transfer things through deeds where they don't have to come into a will. But I think that a will is a great thing to have because you don't know what could happen. If someone has an accident and they pass away tragically, what if your estate has to sue someone and there is a ton of money that comes into the estate? That will is there to ensure that how you would have wanted things to be handled, it is handled that way. And what I can say is I think that it's even worse when you pass away and you don't have, you haven't talked about how you want things to handle. And I know some people I talk to and they'll say, well, I don't care what happens when I die. Let them fight over it, you know? And I think that's the worst attitude to have. Even if you don't have what people would consider a lot, you've worked for what you have your entire life. And I think it's important that you pass it down. Even if it's $15,000, $20,000, that is something that can set your heirs,
Absolutely.
your children up for success in paying off a credit card or
Yes.
helping them to pay for college. So that is substantial, and I definitely think that a will is for all people. Now, when it comes to a trust, so many times people come and they want me to set up a trust for them. And for them, they are just thinking about, well, it doesn't have to go to court. We don't have to pass things on. I don't want people knowing what I have. The issue is that if you have a trust, you need to have assets to put into the
Right.
trust.
Gotcha.
So when we talk about funding the trust, what does that mean?
Right.
That means, have you legally placed things, taken the legal title out of your name and put them into the trust so that the trust is now the owner of it? And so what I like people to do is to sit down and think about what that looks like. If it's a life insurance policy, you cannot take it out of your name and put it into the name of the trust. If it's a 401k, you cannot take it out of your name and put it into the name of the trust, because those are both taxable events. So really, when you think about what you want to put into a trust, you want to think about, do you actually have assets where you can fund the trust? And so many people don't fund their trust.
What are those situations that could possibly happen with the family that's left back?
When families lose property. And when we talk about, for me, when I think about property, it's property that's been in families for generations. So maybe it was your grandmother's property or your great-grandmother's property, and you've never passed it along. So you might have a niece that's living in your great-grandmother's property, and the property is in the name of your great-grandmother. Well, depending on how many children they've had, if she passes away, it could almost be impossible to ensure that you are able to ensure that legal title is in the property. So a new thing that most states are doing is something called a revocable transfer on death deed. And what that
Was that a revocable transfer on death deed?
Yes, it's called a revocable transfer on death deed. And what it allows a living person to do is to say, I'm alive, I am well, this is my property, I want my homestead exemption, I want my over 65 exemption, but in the event that I pass away, this is the person that I want to get my property.
Revocable transfer on death deed. All right. I want to back up. You mentioned something about the importance of when we prepare for our will, being able to assign someone guardianship, and something else you said, where you can have multiple people in different roles. Can you talk about that and the importance of that?
Yes, so the sort of 4 roles that you are likely to have would be an independent executor, if you have to have a guardian of trust, and a guardian of persons. An independent executor is really the person that's going to handle all of your affairs of things that fall under the will. So that can mean if you have to sell a house, if you have to convey property, they'll sign what is called an executor's deed, where they transfer the property from the estate to whomever is listed as a beneficiary. They open accounts, they write the checks. They are really in charge of handling your finances.
Now, what happens if this has not been prepared, if there's not been a will or any type of estate planning, the parent or parents pass away? What happens to the child then?
And that's what gets complicated, because multiple people will believe, your mom thinks she wanted them to raise them, your sister thinks she wanted them to raise them, and then when you have married couples, who do you decide raises them? Is it the paternal side? Is it the maternal side? So the first thing that happens is that I think that it causes conflict while grieving, right? Because a lot of times people feel obligated to do things that you haven't discussed with them, maybe that they're not prepared to do, and maybe that they feel guilty about, right? They feel like, I should do this because I've lost this person. And I think that that's sort of the worst scenario to put someone in. You want to have a will because you want to talk to people about, if something happens to me, I want you to raise my children. This is what that looks like to me. And if you haven't had that conversation, that can be very difficult.
Who wants to talk about death, right? But it's the inevitable. We have to.
The next thing that happens is that there is something called a guardian ad litem that the court will appoint. And the court appoints an independent attorney to interview family members to decide who can be the best person if the family cannot agree.
Wow. So basically you're having a total stranger come in and make that decision for you.
So, you know, and this is why it's such a difficult process, is because the way that guardian ad litems are appointed right now in most states is that there is literally a will that the judges spin. And if you're certified to be a guardian, if your name comes up, then you can be appointed to do that. So if the guardian ad litem is a very detailed, a really good guardian, they're going to interview everyone. They're going to interview teachers to find out who was involved. They're going to interview extracurricular individuals. They're going to interview neighbors. They're going to interview that sibling, because they want to find out who do these children have a relationship with, how, you know, what makes them the happiest. They may even interview the child themselves, depending on their age, to find out. But, you know, you're really at the mercy of the guardian ad litem and their recommendation to the court.
So, so LaMonica, you mentioned to me before, whenever you go out of town with your husband and you leave your kids behind, there's a practice that you do as far as leaving your children and some of their paperwork with a loved one. Can you talk about that?
Yes, so I have this binder and we, you know, keep it in our safe, but when we go out of town, it has a copy of our wills, and it also has sort of what we call an information sheet. So what's on the information sheet is going to be our financial advisor. It's going to be our their doctor's information. So we have their doctor's information, the phone number, we have their school's information, their teacher's names, any information that they need from there. Of course, we also have like a schedule with all of the activities that they need to go to. And we also do have a medical power of attorney. So what we have through, and we go through Kelsey Siebel, they actually have an opportunity for you to upload that through the portal through their healthcare proxy. And you can actually contact them if you're going on vacation to let them know who is going to be with your kids, who has authority to bring them to the doctor's office. And so that is something that is so important. My sister thinks that it is very morbid, but I think that, you know, it's something that's important. And the reason why is that when people used to pass away, so you can't bring a probate in court for 30 days when someone passes away. So what used to happen is that you could literally sit at the house and collect mail. So you could see all of the bills that someone had. You could see who they are paying, if they had insurance or if they had any investments. Now all of that has gone online. So no one has any idea
what's going on,
what, you know, what we have. And unless, let's say that if you have a financial advisor, it could take them weeks to try to find out who they should be contacting. And who's to say that they're getting in contact with the family member that you actually want to contact. So I think that it's very important to equip, because if something were to happen to your kids, whomever is there, there's already so much pressure on them to make the right decision. Equip them with the tools to be able to take your child to the doctor.
You know, I totally get your sister. It is definitely a morbid thought, but you know what? It's very forward thinking. It's a very a wise move, because in the event something happened, if you have things set in place, you know, nothing misses a beat, you know.
Well, and I think about my children as well. I mean, they're my entire world. And so if something were to happen to me, the last thing that I want is, I want something to be stable for them. And so thinking about who they're going to go and live with, are they going to have tools to ensure that they can get therapy? They have financial tools to ensure that they're not struggling. That's extremely important to me, because I think that anyone who loses a parent, it's going to be devastating to them. So as a parent, we have to just ensure that we are doing as much as we can, still sort of mothering them, even when we're not here.
I've read, LaMonica, somewhere where every estate planning should have certain documents, okay? And what are some of those documents that you tell our viewers, hey, no matter what, you want to have these, I don't know, 2, 3, 4, 5, however many that you definitely want to have at your disposal?
Yes, so I will not really, unless it's an emergency, prepare an estate planning package without a will, a durable power of attorney, a medical power of attorney, a HIPAA release, and an advance directive. And so let's sort of talk through what those things are. We talked about a will already, but durable power of attorney and a medical power of attorney are two separate things. Sometimes when you go online and you're looking for some of these things, it may seem as if you can appoint people through the same document, but it's not that way anymore. A durable power of attorney is something that lays out who do you want to handle things, you know, for your business in regards to real estate transactions. If there is a trust that you have set up, if something were to happen to you and you become incapacitated or you're out of the country, what does that look like? There used to be a durable power of attorney where you went through and you just sort of checked all these boxes. Well, those are really not permissible anymore. What the state of Texas specifically wants you to do is to go out and list every single power that you want someone to have. So if it's not listed completely, you can't just have sort of a blanket durable power of attorney that says, I want you to handle all of my business and financial assets.
So you have to spell it out.
You have to spell it out. Wow. And so that is something that is very important for viewers to know, is that you want to be sure that you are using the most accurate sort of durable power of attorney that really lists things. Also, you want to ensure, does it say that it takes into effect when you're incapacitated or for a set amount of time period? Most of the time you want, if you're doing a blanket durable power of attorney that lays out all the powers, you only want that to take effect once you are incapacitated. If you are, you know, I think there was like a mobile closing. My dad had to go, was on vacation, and he gave me a durable power of attorney for that specific real estate transaction so that I could sign off on the closing for him. But it was very specific, and it was just for a set time period. So there are things that you can use in that aspect. And one thing I do want to let people know is that a power of attorney dies when you die. So sometimes, you know, what will happen is that someone won't have a will, but they'll have a power of attorney, oftentimes for their parents. So when they come to us and say, well, I have the power of attorney, I've been power of attorney for my mom for 10 years. Well, once they die, it's over. Now, that can be used if an attorney is appointed to say, well, this is who she would have wanted to handle her estate. She had, you know, this daughter had power of attorney for 15 years. They were handling things, but it's not a necessary right to be able to handle things for a deceased person. So a medical power of attorney, and when I talk about that, I'm going to talk about it with the HIPAA release, because I think that those items work hand in hand. So a medical power of attorney allows you to make medical decisions on behalf of someone when they're unable to make it. So let's say that if someone is undergoing major surgery, or they've been in an accident and they're unable to make decisions for themselves, that's where a medical power of attorney is going to take effect. Now, why would you need a HIPAA release? I would say that you need a HIPAA release, and so let's talk about your daughter. She's 18 right now, but let's say that she's 21. From the age of 18 to 21, you may not be going to all of her doctor's visits with her. You may not be up to speed on all of her medical records. What a HIPAA release allows you to do is to view the medical records, to have access to her medical history, so you can get up to speed and make the best decision based on all of her care that she's had during that time. So that is why I think that both of those documents work hand in hand together.
Okay. And then there was one more, was that it?
That's an advance directive.
Okay.
So a lot of times in advance directive, people call it like a DNR, a do not resuscitate. And it talks about what would you want to happen, you know, to happen if something were to happen to you and you are making end of life decisions, which is very difficult. It's difficult for us to think about, but it's also very difficult for someone to deal with if they have to be the one, you know, and people will say, do you want to pull the plug or, you know, not. I mean, no one wants to have to make that decision in a silo, in a bubble. So an advance directive will give insight into whether it's a terminal illness or an irreversible condition. Do you have different views on what you would want to happen in those instances?
So what happens if that's not been in place and there is a situation where someone has an irreversible situation? Is it just up to the medical team to make that decision at that point?
With the next of kin, and that is such a broad term, right? So when you talk about next of kin, you can be talking about daughters or sisters. And what if everyone is, this causes so many issues for medical teams because they're not sure who they should be speaking with. Should we be speaking with the parents? Should we be speaking with the daughters? If the children are 18, 19, do we want that sort of burden on them to make in a silo? So, really thinking about this, and I say reevaluating every 5 years.
Yeah, I was going to say that's my next question. How often should we reevaluate that?
I think reevaluate it every 5 years. Or if you purchase a major asset or make a large financial decision, you want to sort of reevaluate it at that time.
Now, what happens, let's just say I name, Auntie Kim to be my child's guardian or the person or executor, whatnot. She starts to have some issues. I'm not really trusting her anymore. How can we take her off the will, basically?
So you can either revoke your will and do a brand new one, or you can do a codicil, which is an amendment. One thing that I do want to say, and I, dealt with my aunt, she has her own will and it's like handwritten and she like scratches through and will initial and do all these things. I don't recommend that. One of the reasons why is that to have what I feel is sort of a trouble-free will is there are requirements. And so in the state of Texas, those requirements are to have 2 disinterested witnesses that are coming alongside and saying that they saw you sign this will, you seemed like you were legally cognizant, you're making the decision on your own. So having those 2 witnesses attest to that, signed in front of a notary, so that is going to be the strongest version of a will. It's going to be very hard to contest that will. But, if someone is in the hospital and they write a will on a napkin or they write a will, are those things that we can use? Yes. Are those things that other family members and people can poke holes through?
Yes.
Absolutely. So, in my opinion, I think you want to do it right and get everything that you need so that your family's not grieving and also dealing with issues related to your estate.
Absolutely. Now, we've talked about a lot of stuff and a lot of documents and just a lot of different planning and things of that nature. So for those viewers who are looking and saying, hey, I've got a lot going on, that's not really in my budget to be able to go to an attorney to get all of this, is there another way that people go online and get these forms? Is there another route they can do to protect themselves without having to go into an attorney's office and go about it that way?
So they can go online, but one thing that I would also encourage viewers to do is to look to their local bar association. So what is a local bar association? That is a group of local lawyers who get together and they have various programs in the community. They are trained in certain things. I know that the Houston Bar Association, along with the Houston Lawyers Association, which is the Black Lawyers Association, and bars all over the country, annually, biannually, they actually provide will workshops. So you can actually go and sign up for it, and they will help you prepare your will. There are lots of programs online that you can use. I will not necessarily endorse them, but I do think that if you can find like Texas Lone Star Aid, a lot of these programs where you can get a low-cost attorney who can help you prepare your will, that is what I would recommend.
Right. So Texas being common state, and for those other states that are common state, what exactly does that mean?
So that means that property or assets acquired during the marriage are going to be assumed or deemed to be marital assets. So that means that if you are in your business and your portion of the business for your profits, if you acquire property, anything that you acquire during the time that you are married, that is going to be coupled with both people in the marriage, and it's an asset that is jointly owned.
What about for couples that live together, may even have a family, they are not legally married? What happens in the event, A, there's a breakup, or B, one or the other passes away, but it's not a legal marriage?
So that is where, once again, it's almost sort of like what we talked about, where you have to get an independent attorney. You have to prove that, you know, this person considered you to be their wife. And so what are some ways that you can do that? Did they have you on the deed? If someone passed in the marriage and there was an obituary, this is where a lot of times we use these things. Their parents may have passed away, and in the obituary they name all the children and they name their son, and listed right next to them is the person that is the common law wife. So I tell people all the time, and this is something that my family does, is that, you know, in the obituaries they'll put people's names, and oh, she was like a daughter, she's like a cousin, an obituary, a family Bible, all of those things can be used to prove that you were looked at as a wife. And so, but you have, you know, you then have to prove that you were. So you have to spend money doing that. You have to hire a lawyer. And I think it gets even more complicated if that person has children that are not of your union.
Right.
So if they had children beforehand or they had children afterwards, the children actually have a stronger case because they are legal heirs than your right is. And so it becomes the presumptions that you have to overcome.
So for those ladies that are not legally married, what can they do to sort of have some little bit of security there?
I think they need to get legal title. So you want to be put on the property as a joint owner. You want to be put on the bank accounts as a co-owner of the bank account.
So is there anything else that you think that the viewers can benefit from, particularly women, single mothers?
I think it's important for us just not to silo our roles. It's good for us to know what everyone's good at. So if one person handles the finances and one person kind of handles things for the children, I think that that's great. But I also think that it's important for us to have knowledge about sort of what is going on that's going to affect our children, and then also to name alternates. So a lot of times we'll name beneficiaries, or we'll name guardians, or we'll name executors, but we haven't named an alternate. And if something were to happen to that person, you want to be sure that you've named an alternate, and then you want to have conversations with those people to see if
make sure they even want that role. They may be like, I don't want your child.
So to have conversations with them about what you would want to happen, or what's the most important to you. And so I think that that's also important, is that also have conversations with the people that you've named as in these roles, so that
it's no surprise, like knock, 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 here's your new family. So LaMonica, one of the things with us being in this season of COVID and a pandemic, you know, one of the things that I've learned, or really been reminded of, that life is fast, it's fleeting, and it's not fair. And we have loved ones and people that we know that we see that are alive and healthy 1 minute, and then the next minute they're struggling with COVID, and unfortunately they're not always pulling out of that situation. And so I think that, you know, today's discussion is really important. Just it's a reminder of the importance of getting our affairs in order now. We all like to think, oh, I'll do that later, or oh, I've got years to do that. When I get older, I'll take care of that. But, you know, this is just a season that tomorrow is not promised. And no one wants to think about, I don't want to go sit with some attorney and talk about, you know, death stuff. But I think it's a wise choice, and it's the adult choice to make, that we go and we handle our affairs and our business. And I so appreciate you coming, because so many times we're not thinking about this. You know, we plan for everything else in life, but we're not really planning for the inevitable. And so I just want to say thank you for coming and for dropping so many gems and sharing your 2 cents. And I know I've learned a lot. I know our viewers have learned a lot. So before we get ready to put a bow on our time together, what are your top 2 cents that you would like to share with our viewers, things that they can apply to their life like right away?
Okay. So the first thing that I would offer is, there are things that you can do if you do not have a will. The first I would say is to go to your bank and put payable on deaths on all of those things, to designate beneficiaries, update it on your insurance policies, on your IRAs, on any of your stock, anything that can transfer outside of probate where you're able to name who you want that asset to go ahead and do that. That would be the first thing that you can do. And then the second thing is to just say that estate planning is for everyone. It's not a one-size-fits-all package, but it is something that you want to do to think about the legacy that you are leaving. And everyone has a legacy that they're going to leave on this world. So I just encourage you to explore what that looks like.
Yay, thank you. And for our viewers out there, because there's someone saying, oh my gosh, I got to get a hold of Miss LaMonica Love. How can they get a hold of you?
So you can go to my website, www.lamonicalove.com. You can book an appointment there. You can call my office. I'm also on Facebook, Instagram, all LaMonica Love. So I look forward to reaching out to you and assisting you.
Yay. Thank you. Yay, that was fun.